All right, here we go. Here we go. We're on torts negligence. So whenever we're doing a torts essay, we want to start off by saying a plaintiff must prove duty, breach, causation, and damages. A duty of care is owed to all foreseeable persons that may be injured by a defendant's failure to meet the reasonable standard of care. The standard of care is that of a reasonably prudent person under similar circumstances. Okay, remember, standard of care is the reasonably prudent person. That's the duty. And it's owed to foreseeable plaintiffs in the zone of danger. There's no duty of care for unknown trespassers. For known trespassers, you have the duty to warn of known dangers. For licensees, a licensee is a social guest, etc., and you have a duty to warn of known dangers. An invitee involves things like businesses, and you have a duty to warn, inspect, and make safe. For example, a spill at the grocery store. The duty of a parent is that the parent knew or should have known that the child was likely to cause harm. In general, there's no duty to rescue, but if you do, you have the duty of reasonable care. So if you assume the duty, you have the duty of reasonable care. There's also a duty if you have a special relationship with the person. And examples of a special relationship are common carriers like planes and buses, innkeepers and guests, teachers and students, employers and employees. That's 4 special relationships. Number 1, common carrier. Number 2, innkeeper guest. Number 3, teacher student. And number 4, employer employee. The duty of the child's duty, if the child is being held responsible or being accused of something, that child has the duty of, that standard of care for that child is the same standard of care for other children of same age, experience, and maturity. The duty of a professional is the duty of a professional or the standard of care for a professional is a professional with similar professionals with same education, training, and customs. Examples being doctor, lawyer, athletes, etc. And that standard is the same even if the person is disabled. All right, so you breach that duty that is owed when the plaintiff fails to meet the standard of care, period. Moving on to causation. You need to have actual cause and proximate cause. Actual cause is the but-for standard, and that's typically always met for MBE questions. Proximate cause, it deals with foreseeability, and you must meet both actual and proximate cause. Now, the question of foreseeability comes in when they start talking about the person being injured after the fact. When it's just you to me, proximate cause is always foreseeable. There can be intervening causes and there can be superseding causes. An intervening cause is always foreseeable. It's a foreseeable event, and that person, that plaintiff, is responsible for all damages. So if that person, if the defendant is injured by the plaintiff and then they get an ambulance and the ambulance is in an accident and they're injured more, the defendant is still responsible for all those damages because that is a foreseeable event. It's an intervening cause, but it's foreseeable. A superseding cause is an unforeseeable event, and that is what cuts off liability. But that only occurs with acts of God, intentional torts, criminal acts, or the fact pattern on the MBE will tell you that it was an unforeseeable event. So if it's an unforeseeable event, that cuts off all liability. Then, of course, you have the damages aspect. So there must be actual harm, physical harm, some type of actual harm must occur for a negligence claim to go through. can't just be economic loss when you're talking about negligence claims. Must prove actual injury, not just economic loss. All right, and one thing that we need to be sure is that we're remembering to not mix up negligence per se claims, and res ipsa loquitur claims, because they're different things that require different rules. Negligence per se claims involve violating the ordinance or statute. The injured party is of protected class, and the injury is of the type the statute was trying to prevent. So, negligence per se claims involve violating an ordinance or statute. Number two, the injured party is of the protected class that the statute intended to protect. And number three, the injury is the type of injury that the statute was trying to prevent. Okay, so one, violation of an ordinance or statute. Two, injured party is of protected class. Three, injury is of the type of statute. Injury is of the type of injury the statute was trying to prevent. For example, John is driving 50 miles per hour and he hits Joey. Joey's backpack flies off his body and hits an old lady who breaks her hip. Can the old lady sue John based on negligence per se? And the answer is no, because what it doesn't say is that John was driving 50 miles per hour in the school zone. And so the old lady is not a student, and she's not the person that was supposed to be protected by the ordinance and statute that says you have to drive slower or 20 miles per hour in the school zone. Now, he still will probably be negligent, but he's not going to be negligent per se. So negligent per se strictly talks about statutes and ordinance, the people who the statute or ordinance is supposed to be protecting, and the injury that the statute or ordinance attempted to prevent. All right, I hope that makes sense to you. We're going to move on to res ipsa loquitur. Res ipsa loquitur is the third topic under the umbrella of negligence, but once again, let's not confuse any of the negligence questions with one another. So, res ipsa creates an inference of negligence if accident would not normally occur unless negligence has happened and defendant had exclusive control. So, with this situation, it typically is going to ask you about whether there's a liability for damages. So here are some tips that we're just going to go over real quick. For negligence, there is typically they're going to ask you about liability for damages. For negligence per se, they'll ask you if a person is liable for violating a statute. For res ipsa questions, they're going to be asking you about inferring negligence. So whether a jury could find you negligent for something. It's not really about proving liability. It'll say something like party stipulated facts, where certain facts are undisputed. I'm sorry. It'll also talk about directed verdicts, summary judgments, etc., etc., etc. But you just need to make sure that you're understanding that res ipsa involves questions that, or hypos that create an inference of negligence, because the accident would not normally occur unless the person was negligent. So, John is walking down a quiet residential street. There is no wind with a beautiful blue sky. John walks past your home and gets hit on the head with a flower pot. You were the only one home. Is there an inference of negligence? The answer is yes, because there is no other reason why this flower pot would just be falling. And one thing that's important in this hypo is that you had exclusive control over this flower pot. John operates on you. You wake up with a scalpel in your gut. Is that the kind of thing that doesn't happen absent negligence? The answer is no. So can you infer that there's negligence if there's a scalpel in your gut? The answer is yes. So that's a res ipsa thing. Um, all right, we're going to move on to attractive nuisances. Attractive nuisances aren't tested often, but let's just go for it. So an attractive nuisance is an artificial condition causing children to trespass. Elements of attractive nuisance: owner knows of child trespassers, unreasonable risk of harm, children cannot appreciate the risk, cost of remedy is less than the danger, and the owner fails to make it safe. This usually tests based on the child's age. Attractive nuisance is something that deals with children. You'll know it when you see it. All right, we're going to move on to defenses to negligence. Pure comparative negligence is when a plaintiff's damages are reduced by the percentage of fault that they are at. And that can be if the plaintiff is 99% at fault and the defendant is 1%, then that means that the plaintiff will be entitled to 99% of 1% of the damages, but they wouldn't be entitled to 99% of the damages. So that's pure comparative negligence. And apply pure comparative negligence unless they say otherwise, which they will. They'll always say, assume you're in a pure comparative negligence, or they'll say you're in a contributory negligence jurisdiction. And a lot of times you'll see that and it doesn't even have any real relevance to the question, because part of it is to kind of throw you off your game, but other part of it is that if you know the rules, you won't have an issue. Modified and modern comparative negligence is when a plaintiff cannot recover if more than 50% at fault. So in modern or modified comparative negligence, 51%, if the plaintiff is 51% at fault, they can't recover. Contributory negligence, the plaintiff cannot recover if at fault at all. So contributory negligence means if the plaintiff is even at 1% fault, they can't recover. So comparative negligence, they can recover the percentage that they are not at fault for. Modified or modern comparative negligence, they can't recover if over 51%. In contributory negligence, the plaintiff cannot recover if at fault at all. There is a last clear chance exception that goes with contributory negligence, and that's if defendant had the last clear chance to avoid the accident. Defendant did not do so, the plaintiff can recover. Okay, for example, John is texting and driving. John runs into you. You glance at your phone, and it turns out you were 3% responsible. In a contributory negligence jurisdiction, you could recover if John could have swerved the car to avoid hitting you. But if he couldn't have swerved the car, like if swerving the car would have ran over a baby or something like that, then you can't recover. Okay, another defense is the assumption of risk. So a person assumes risk when they have knowledge and they appreciate the danger. Another defense is joint and several liability. Joint and several liability occurs when two or more people cause a single accident. All defendants jointly and severally liable for the damages. This means that the plaintiff can collect damages from one person if they are both joint and severally liable for the injury. In that case, a defendant can sue for contributions. And a contribution is where a co-defendant can sue to recoup the money that they paid out for a claim that they were joint and severally liable for. So they can sue their defendant to try to get some of their money that they paid back. Vicarious liability. Vicarious liability. Employer is liable for negligent employees who are acting within the scope of employment. Generally, employers are not responsible or liable for independent contractors, unless there's an abnormally dangerous activity and the duty is non-delegable. A non-delegable duty or duties that involve safety or benefit to the public. A non-delegable duty example is chopping off ice on the sidewalk, cleaning windows, polishing floors in office buildings. A non-delegable duty, oh, I'm sorry, a delegable duty or not a non-delegable duty is redoing John's bathroom, okay? And an employer may seek indemnification from whoever actually caused the damage, i.e. the employee, but the employer would still be held vicariously liable. And yes, an employer could sue their employee um, for damages that they paid out, but did not actually cause.